Cross-examination. Cross-examination is your opportunity to ask questions of an adverse witness, of somebody who is not your witness. You're usually not having a friendly discussion with that witness because they're usually testifying for the other side. There's some occasions where it might be productive, that witness might be helping you, but the principal thing to learn about cross-examination is you're doing exactly what you talk about. You're cross-examining that person. You're asking questions to get them to admit something, to get them to concede something, to get them to say something. Cross-examination is critical in order to be successful at trial. As you contrast that with direct examination, you're telling your witnesses the story. You're telling them the story through your witnesses. The other witnesses get up and say, it didn't happen that way, or that person isn't truthful, or I didn't see it that way. And your chance, after they've done their direct examination of a witness, is to cross-examine that witness, to be able to ask them what they said on direct, to be able to show them that what they said may not have been as accurate, or even if what they said is true, that it still helps you. So in cross-examination, I still go through the same pre-examination analysis. I say, what is my objective? What am I trying to accomplish in that cross-examination? Do I want to get the witness to concede that they didn't pay the money? Do I want to get the witness to concede they really didn't see the gun go off? Do I want to get the witness to say that they admit that they really weren't in the place they were? Whatever it is, I have to learn my objective. I have to learn what it is that I want to accomplish so that I can get up in cross-examination and do that. Different from direct examination, where you're telling a story, or you have a witnesses tell parts of a story that make up for a larger story. In cross-examination, it's very limited. I am trying to get that witness to do one thing, to do two things. The key on cross-examination is to be surgical. I'm going in and I'm going out. I am not debating the witness. I am not engaging in a long-winded discussion. I am simply trying to get them to admit or deny something, to concede something, to agree with me about something. Cross-examination, therefore, has to be controlled by you. That means you have to lead. You have to ask questions that you know the answer to. You have to ask questions that move the witness to where you want to go. You own the witness. When you stand up, remember that. If you understand that, then you'll frame your questions in a way that they can't control you. If I say, where were you standing at the time of the accident? That's a different kind of question than, isn't it true you were standing on the north side of the road during that accident? Yes. And isn't it true that there was a wall that went up on the north side that actually goes directly in front of the intersection? You see what I'm doing? They have to answer yes or no. They can't say, well, I wasn't standing there. They can't start explaining it. They're asking or answering a question based on what I ask. I am pulling them where I want them to go. If my point was to show that they were not available, I might say, as you saw in direct examination, there's a picture. Let me go to exhibit number 3. I pull the exhibit up. It's a picture of a wall. And I say, that is the picture of the wall that's on the north side of the street, isn't it? Right? I mean, we all agree to that, don't we? Yes. Okay, can you tell me where you were standing? Okay, now the person could say they were standing somewhere else. If I say, isn't it true on direct examination, you were standing right behind the wall? Isn't that what you said? You said you were standing next to the poster. And you see the poster in this picture, and it's behind the wall. Well, yes, I guess I was. Now, I don't have to say, well, isn't it true you're a liar? They're already a liar. They already can't tell you that they saw the accident. So cross-examination is not for killing the person. Cross-examination is not for closing argument. Cross-examination is to lock that person into what you want so that later on in closing statement, in closing argument, you can go forward and say, let me show you what that witness said. You remember? I asked them this question and they answered that? Or if you're videotaping the trial, or if you have a transcript of the trial, because you can actually have it transcribed while you do the trial, I can say, let me read to you what they said. It's being filmed. Let me show you the video of what they said. So it's very important to understand that cross-examination, in its surgical nature, is usually shorter, is usually tighter, and I'm asking leading questions. Isn't it true? Wouldn't you agree with me? Didn't you say on direct? A lot of times, if you want to emphasize something, you might want to use what they said on direct examination. So let's say the witness said that they were standing in a place where the light was, and that they saw the light was green. And you have a deposition from 2 years ago where they said the light was red. you may want to, on cross-examination, say, so sir, in your direct examination, you said you were standing at a place where you could see the light. Yes, I was. And you said that the light was green. And the person says, yes, that's what I testified. I mean, you just testified to that, right? Right. Okay, now, I've repeated it because I want to emphasize that they've said the light is green. Now I say, well, do you remember telling me several years ago that the light was red? No, I don't. Or yes, I do. If they say no, I can bring out the video and say, isn't it true that you answered the following question, or that you were under oath and you gave the following answer to the following question? I can play the video, I can read the excerpt of the video. Or yeah, I was standing there and the light was red. There's no doubt about it. The light was red. Now, I don't say to the person, wasn't she you're a liar now? I don't have to do that because I have shown a jury they are liars. Okay? I don't need to go into that diatribe with that witness. I've proven that they're inaccurate. Now, if I wanted to explore that, there was a reason why, because maybe I want to get them to change your testimony, I would say, would you agree with me that your memory closer to the time of the accident probably was better? I mean, you remember things 2 years ago, a lot better 2 years ago than you did now, right? Yeah, that's probably true. So you see what I've done? I might want to go into more if I'm trying to lock them in, but I better be sure that they're not going to say, no, well, back then I wasn't sure, I was pressured, I was this, I was that. So you want to make sure you're going to know that answer. But the key to cross-examination is, you see, I'm leading that witness. I'm locking him into that statement. Wouldn't you agree that you signed the contract? I mean, isn't that your signature? Didn't you tell us on direct it was your signature? Yes. And you certainly understand that the contract says that when you receive the 200 footballs, you got to pay $2,000. I mean, that's what the contract says, right? They either say yes or no. If they say yes, I don't need to go any further. If they say no, I say, well, wait a minute now. Let me go get the contract. Let me take exhibit. Judge, may I approach the witness here? Let me show you. You see in the contract? Why don't you turn to page 2? Why don't you read what page 2 says, clause number 3? Read it out loud. Once I get the 200 footballs, I must immediately go to the website and pay. I've now got them locked in. See, I don't have to say, well, isn't it true I'm right and you're wrong? Why don't you apologize to the jury? The concept is cross-examination is surgical. It's limited. I'm using it for impeachment. Also, too, just like direct examination, what do you want the jury to get out of it? Do you want the jury to think the person's a liar? Do you want them to think they're mistaken? Do you want them to think, well, they're just have a bad memory? What is the emotion you want to convey? And that will also tell you the way in which you ask the questions. If you say, you're not telling me that you were standing on the north side of the street and saw the intersection when the cars came through. See what kind of demeanor I've asked that question in? It's almost like a, are you kidding me? It's almost like a way of saying you would have to be a compulsive liar. Versus, now I know it's been a couple of years since the accident occurred, and I'm not sure whether you recall or not what happened, but is it possible that maybe you forgot, or that the light was actually red? That's a different way of approaching. I want the jury to feel like, okay, maybe the person's mistaken. Maybe they're a likable witness. So that psychological component plays a role in these examination questions. It's not just I'm asking the questions, it's what effect do I want the jury to have. Again, if you have objections in cross-examination and the lawyer is to your left, when they say objection, that question is hearsay. You don't say, I'm going to fight with the lawyer. You remember that the judge is in front of you. I'm going to look at the judge. The judge will either rule or say, Mr. Major, do you have a response? Yes, it's not hearsay because this is an admission of a party opponent. This is an exception under the federal rules or the state rules. I'm not looking at that person. But judge, blah, 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 blah. I still don't look at them. Mr. Major doesn't know what he's talking about. Mr. Major dresses funny. Mr. Major's ugly. Mr. Major, I'm still looking forward because the jury's looking at me. No matter what happens, I'm an elegant professional. No matter what happens, you're an elegant professional. If you understand that, the way you conduct yourself, the way you set up your witness, the way you ask your question has an impact on how the jury responds, you will succeed in all of these kinds of examinations, particularly in cross-examination when it's your job to confront usually an adverse witness. So take your time, be prepared, be surgical, be short, understand your objective, know what feeling you want the jury to have, and you will succeed in cross-examination.